Okay, so it's 10:02, so I think we're going to get started. Thank you everyone for joining. Good morning. This is it's Wednesday, it's 10 a.m. and this is part of the SCORE Monmouth webinar series. Today we are hosting a webinar about employee versus independent contractors, and our presenter is Joanne Farina from Paychex. She's an HR sales consultant and really well versed on the topic of employees versus independent contractors. It's an interesting topic. It's something that I think a lot of people struggle with and are never quite sure what's right and what's not right and what the risks and exposures are. So it's going to be great subject matter for us to take away. A couple of quick housekeeping things. If you have any questions, and we do encourage questions, we like to take questions, please put them in the Q&A function in the Zoom app. Try not to use the chat function because we find that harder to monitor, and we want to make sure we get to all your questions. We encourage questions, so don't be shy, go ahead and ask. We are going to try and run through the presentation and then answer the questions at the end of the presentation as opposed to during it. If we see a bunch of questions coming in of similar nature, we may take a break and answer them, but just note that. So Q&A function is the best way to ask your questions. We are streaming this live on Facebook as well. So if you need to rewatch it, you'll be able to see it on Facebook, and we will post it to our YouTube channel once we're done. I think that's it. So I'm going to pass over to you, Joanne, allow you to, take it away, do your introduction and go ahead.
Well, thanks so much, Claire, and good morning, everybody out there participating in today's webinar hosted by Paychex and SCORE on the ever-changing, curious, uncertainty type of topic with regards to employee versus independent contractor. Just a little bit about myself. I've been an HR sales consultant with Paychex for 13 years, and I've been working with the SCORE group for the past several years, and I'm always so grateful for the opportunity to talk about important content as it relates to the business community. You'll see at the bottom of the right-hand slide here, this is our disclaimer. We're going to talk about a lot of stuff today with regards to IRS and various employment laws that come into play when identifying, trying to determine whether or not a worker is an independent contractor or an actual W-2 wage earner employee. And, we do require that you seek legal advice or other professional assistance. As always, this is more of an informative webinar on this topic. All right, so as mentioned, purpose of today is really to help identify, get a little bit more clarity on classification of workers as either employees or independent contractors for purposes of federal employment taxes and income tax withholding. There's a lot of laws that impact the determination of worker classification, as an independent contractor, including the Federal Fair Labor Standards Act. That's one that definitely goes hand in hand with classification. But, for sake of subject matter, we're really going to focus more on the IRS considerations. And this classification of workers as independent contractors rather than employees has led to substantial losses, both in potential revenue for the federal government as well as for businesses, because there's a lot of penalties and fines and back interest that is associated with this. So let's get started. Some examples of workers who may qualify as independent contractors, people such as doctors and dentists, you have your veterinarians, lawyers, accountants, contractors, subcontractors who are an independent trade, business or profession in which they offer their services to the general public are often independent contractors. However, big however, these people are independent contractors or employees will depend on the facts of each case. And the general tax rule is that an individual is an independent contractor if the payer has the right to control or direct only the result of the work and not necessarily what will be done and how it will be done. So employers have, some tax-related obligations when they have workers classified as employees. Some of them must, right? You have to pay taxes. You have to withhold the income tax, pay half of the tax, mandated under FICA. withhold employee shares of FICA, pay the full tax required under FUTA, and any state-related laws as well, in addition to paying for workers' compensation insurance and filing returns with the appropriate tax authorities, and of course, providing the W-2 forms for employees, excuse me, no later than January 31st of that calendar year. And employers who do not comply with these employment tax laws may also be subject to criminal and civil sanctions if found willfully that they are avoiding to pay these taxes. So the National Labor Relations Act, Title VII of the Civil Rights Act of 1964 and the Fair Labor Standards Act as well, states that laws address workers' coverage. So, excuse me, when determining if an employee or if a worker rather is an employee or an independent contractor, again, there's a lot of considerations that the IRS states an independent contractor would be, in terms of tax purposes, but simultaneously, considered an employee under, other law like a Fair Labor Standards Act could be quite different. So, however, these two different, we have the Department of Taxation, IRS, and then we have the Department of Labor, where the Fair Labor Standards Act, kind of rests. These like different tests that you can go through, like the 20 factor test, can be used to help determine that. It's a popular analytical tool today, but some of the factors are no longer as relevant as they once were either. And so the determining factor of whether a worker is an employee or an independent contractor depends primarily on the extent to which the person receiving the services has the right to direct and control the service provided. It's not necessarily for the employer to actually control the way in which services are performed, but they must have the right to do so. And we're going to talk a little bit more about this in just a minute. Again, the employer controls how an employee performs the work, and independent contractors generally determine for themselves how the work service is performed. So the relevant factors used to indicate the extent of direction and control present in any work situation fall into three categories of evidence. These categories of evidence incorporate many of the factors originally included in the 20-factor test that I just mentioned, used by the IRS. Not all factors need to be present in any given situation, and no single factor is considered controlling. So this triangle here that we're looking at reflects the primary categories of evidence as described in IRS guidance. Introducing these categories, behavioral control, financial control, relationship of the parties. When we're talking about behavioral control, we're talking about whether or not we can illustrate a right to direct or control how the worker performs the work for which he or she is engaged in. So, kind of a few examples here would be like what kind of instruction or training they're being provided. Financial control, facts, that are illustrated would be, do they have the right to direct or control how the business aspects of the worker's activities are conducted, including things like opportunity for profit or loss, significant investment, unreimbursed expenses, as well as method of payment.
Joanne, I have a quick question for you on that. Is this
Yeah.
what you're talking about, the ABC testing? Is that what this is?
Yeah, excuse me, great point. So this falls under the ABC testing for sure.
Okay, thank you.
So the 20-factor test is a series of questions to get you thinking: is this individual considered a worker, or the worker considered an employee or independent contractor, and is still used very heavily in audits. But when we're looking at these categories of evidence, it falls more along the lines of what's commonly known as the ABC testing.
Okay, thank you.
Yeah, thank you. excuse me. So financial control, we just went over that, and then the relationship of the parties. So when we're talking about relationship of parties, it's really including is their intent, employee benefits. Can they be, discharged and terminated, continuing relationship and other business activities, written contracts, things of that nature. So taking a little bit of a deeper dive into behavioral control, most every business imposes on workers some type of instruction, whether they're employees or independent contractors. This alone would not generally be a determination of the worker's status. What is critical, though, is to look at, with regard to instructions, things like the scope of instructions, extent to which the business retains the right to control the worker's compliance with the instructions, and the overall effect of that worker on the event that could be considered non-compliance if they were to fail, to comply with those instructions that are given. And these factors provide clues, again, to just help identify independent contractor versus, employee wage earner. The more detailed the instructions are to a worker to follow, the more control the business will be considered to have. And so it could be a knockout factor there, depending on the type of, instruction. So for example, if a worker is given extensive instructions about certain aspects of the work, this is generally evidence that he or she is an employee. So things like when to do the work, where to purchase supplies or services, what work must be performed, what routine or patterns may be used, what order or sequence to follow, where to do the work, what tools or equipment to use, what workers to hire to assist with the work if need be. Those are just some examples of what would be considered extensive instruction and can certainly be a knockout factor. With training, if periodic or ongoing training is provided by a business with certain procedures that have to be followed or methods that have to be used, this typically also indicates that a business wants the services performed in a particular manner, and that type of training could be strong evidence that there is that employer-employee relationship. Financial control. So is there an opportunity for profit or loss? The ability to realize a profit or loss may be the strongest evidence that a worker controls the business aspects of services rendered. Generally, this may be determined by looking at the following, like 4 types of evidence, such as significant investment, unreimbursed expenses, services available to the public, and method of payment. We're going to take a deeper look into what that really means. So the first one here is significant investment. If a worker invests in facilities that he or she is using to perform the services and work, that could be, an indication that they're, a properly classified independent contractor. Facilities are things like, office that they rent, at fair market value, or some type of permit, things like that. And when we're talking about unreimbursed expenses, this is in the event that a worker's business expenses are paid by an employer, the IRS will usually find her to be an employee. So money is being exchanged for expenses, between the two parties could very well deem that that's an employee-employer relationship. Services available to the public, independent contractors often advertise and maintain visible locations. So, as to be available to work for the general public. And, they're also free to seek out business opportunities of their own and also provide services to more than one customer. method of payment. This is when we're looking at, worker paid, by determining the extent to which the worker controls the actual business aspects of those services rendered. And so if a worker is paid by the hour or the day or the month, this could generally also indicate that there's an employer-employee relationship. So what they're being paid, the frequency of what they're being paid, as well as for what type of work is being rendered. Got stuck there. Okay. Okay, so financial control, not all financial control facts need to be present to have the ability to, realize a profit or loss. We just talked that, or just, spoke about, it doesn't necessarily have to be all factors or, just one. It really has to make sense and be reasonable. So, it is important, to note here that, for like as an example, a worker who is, paid straight commission, makes business decisions, has unreimbursed, business expenses, may likely have the ability to realize a profit or loss, even if the worker doesn't have like a significant investment as one of those, criteria that we just reviewed, and does not market services to the public. How are we doing with questions, Claire?
Sorry, I had to unmute.
Just went over a lot.
I had to unmute myself. We have a couple of questions, so I can address those. One of the first question is, often the what is being done has a how component. It sounds as if it may be a matter of degree. We have trainers who deliver several webinars a month for us. So we provide the platform, the presentation, and provide best practice delivery guidelines. They are responsible for own subject matter expertise. So with the new guidelines for 2021, having a bit of difficulty passing some of the considerations, what will be used to clarify those categorizations? Wow, that was a lot of words.
Yeah, that's a doozy. So there's a lot there, and I, as mentioned, before we got into the content being delivered in today's webinar, there are cases where you may want to seek, legal and professional advice. We're going to get to in just a moment a form that is available, via the IRS that can be completed and submitted. Again, we also recommend to any business owner when they're doing that, you may want to speak with an attorney to find out what some of the legal ramifications might be, in the event it is deemed that this individual should be an independent contractor versus, a wage earner or vice versa. But yes, there's a lot of stuff changing with regards to how workers are classified. And so, as a reminder, this is really focusing on how the IRS looks at it. And there are various employment laws, under the Department of Labor, that you will see some overlap, but you'll also see some differences. So I would agree. I think it was not necessarily the what, but the how. And that goes back to the ABC testing that you were referring to earlier, Claire. What kind of actual control is really there to help really determine, is this individual somebody who I'm depending on a lot, who's given these trainings very frequently, who's receiving, some of the same pay. Is he or she doing something similar for other types of companies? There is a lot to consider with that one. And I'm also, I'm also happy to take, any questions offline. I'll share my contact information at the end of the presentation.
I guess sort of, this wasn't part of the question, but I would just kind of add to that question. If the person you're hiring is an LLC, does that minimize or mitigate some of the risk if you're unsure, if you're paying an LLC as opposed to paying an individual directly?
So that's a really great question. And, in my experience, I'll share that we were working with a company who provides floor installations for customers of Home Depot. And this particular company was paying subcontractors who were considered an LLC, right? And the LLC was one individual. So Joanne Farina
LLC.
doing business as, JF was LLC. In that particular audit, the IRS determined that that was in fact misclassification, and that LLC was more of an independent contractor type of scenario, whereas that individual should have been a wage earner W-2 employee because of the percentage of wages they were earning from this floor installation company that had the relationship with Home Depot.
Got it.
So it's a very gray area, very, very gray. And there are a lot of, changes that are being discussed, and, again, want to provide the content, but in scenarios like that, where it's super gray and murky, the best advice is to talk to either an attorney or a certified, professional accountant, or some type of enrolled agent that can help determine that with them.
Great, thank you. And then another question is, back to the previous question from Jan, is there a place you can find a list of sort of knockouts or major considerations?
Absolutely. So the IRS website has the 20-factor test that I mentioned earlier. It also goes into detail about the ABC testing, these controls that we're discussing today. And it also has the form, which we're going to talk about in just a moment, in a couple of slides ahead, where if somebody, an employer wants to proactively get the IRS involved to help with that determination, they can fill out this form. It's a pretty extensive and time-consuming application process, but if you're looking, for their input to be proactive, then it's a good route to take. But the IRS website has all the information.
Do you think, just kind of capitalizing on what you just said, that I know a lot of people are fearful of posing questions to government entities and agencies because they don't want to draw attention to themselves? Do you think that being proactive is something that is more beneficial, because at least you have some proof that you did, you may come up with, whether you decide to go ahead with W-2 or 1099ing someone, if you've been proactive and done your research and you can document that and show that you kind of went through all the steps to come up with your findings, does that stand in your favor, do you think?
Yeah, it's always good to be proactive. What I will say is that I don't necessarily know of too many businesses that went the route of providing the information to the IRS for determination. Not to say that it's good or bad. I just, in 13 years, meeting with thousands of business owners, I can probably count on one hand how many individuals have gone that route. But it is important, and I can't emphasize how important it is to be proactive and do your due diligence to really understand the difference between the IRS regulations as well as the Department of Labor to properly classify. So, this content is more designed around federal, but in New Jersey, and I know a lot of folks on this call, if not all, are New Jersey based. A couple of years ago, the governor and administration created a misclassification task force. And, reason being, there's multiple, but tax revenue is being lost. We talked about that just, a moment ago, for the government. Employers, if they're misclassifying their workers, are also not paying into the state unemployment fund or disability or workers' compensation for that individual. So the employee, if they're deemed an employee, it's certainly losing out on benefits. So there's a lot of different reasons why there's so much scrutiny on properly classifying workers. So it's important really to just do your due diligence in one way or another to make sure that you do have that justification as to how you came up with this worker being an independent contractor or a wage earner.
And again, I mean, and not to be alarmist, but I was having a conversation with someone yesterday, and they said they had it was an attorney, and he had a customer who had misclassified somebody in New Jersey, and they had to pay $100,000 penalty to the IRS for that. Either the IRS or Department of Labor, I'm not sure which, but they had a $100,000 penalty, and they had to back pay all the what would have been the withholding taxes. Even though they hadn't withheld the taxes, the company was liable for those withholding taxes, which just to me highlighted that, how important it is to get it right in the beginning.
Mm-hmm. Yeah, and we just had I just had a similar presentation on this topic with a local CPA firm, and one of the partners shared the same thing, that despite her direction and guidance that this individual should be, or individuals, should be wage earners, the business was paying them as 1099 independent contractors, and the individual went to go file for unemployment. Back to what I just said a moment ago, they're not subject or eligible rather for unemployment benefits as an independent contractor, so that triggered an audit. And I don't know, it wasn't as much, but certainly there's back wages and penalties and interest that are due, and that's where it can be a very negative impact to especially a small business.
That's for sure. Okay, so there's a couple more questions, but do we want to, and I see them in there, so the people that pose them, do you want to maybe move on with the presentation a little bit, and then we'll take some more questions?
Yeah. Yep, sounds good. Yep, let's keep it moving. Let's go. All right, so financial control, moving over to relationship of the parties. This last category of evidence is really, the intent, right? We talked about the intent before. And some of the factors to consider here are, whether or not a written contract exists between the employer and the individual, whether or not the worker is receiving benefits by this employer, whether or not an employer may terminate the worker without penalty, as well as the length of the relationship. So, intent of parties, difficult to decide, whether a worker is an independent contractor or an employee. The intent of parties as reflected in the contractual designation may be helpful. There are several court decisions that have looked at the intent of parties, and most often they will embody their contractual relationship. And so a written agreement describing the worker as an independent contractor is viewed as evidence of the party's intent, but still not in and of itself sufficient evidence to determine the ultimate worker status. And this is a big one. If an employer is granting a worker, benefits, this is also strong evidence that he or she should be classified, as an employee. So providing worker benefits, things like, vacation, sick time, health insurance, pension, retirement plan, those types of benefits are traditionally associated with an employee status. Evidence is really strongest if the worker is provided benefits under a tax qualified retirement plan, or cafeteria plan. That's really what it's commonly known as, but it's also referred to as a Section 125 plan. These benefits are provided only to employees because of those tax advantages. So, and by way of tax advantages, I mean that they're allowed to either contribute to the retirement plan or to their medical plan pre-tax, right? So before their gross wages are taxed, they're paying for their medical or contributing to a retirement plan. And for, an employer, failure to provide, fringe benefits, should not necessarily be considered evidence of independent contractor status. But, none of these benefits are required for that type of, relationship. Discharge and termination, continuing relationship, the right to discharge a worker and the right to terminate work without incurring penalty have also traditionally been used to help determine worker status. If an employer is able to discharge the, individual, it's really evident that he or she exercises control through the threat of dismissal and causing the worker to obey, employer instructions. The continuing relationship, also points to the existence that there is an employee-employer relationship. If a business engages a worker with the expectation that the relationship will continue indefinitely rather than for a specific period of time, duration of a project, this is generally evidence of an employer-employee relationship. Regular business activity looks at services performed by the worker and the extent to which those services are a key aspect of the regular business or function of the company. So, if the services the worker performs are part of the company's regular line of business, it is likely that the company will wish to control how those services are performed. So if you're hiring, a web designer, versus having, somebody in-house, to manage IT, that's a good example of, regular business activity. Quick little summary: employees, you're withholding, their taxes, you're providing them a Form W-2 at the end of the year. Independent contractors, the individual themselves are responsible for, any taxes, and they're receiving a 1099 miscellaneous income statement from you as the employer. And, there are some risks, which we, briefly mentioned before, penalties and fines and back wages. The exposure for misclassification clearly is serious, and it's not to be an alarmist. But cash flow is important to small business. And we want to make sure we're doing things right so we can account for every dollar and every cent. These ramifications are going to be determined, though, by whether it's found that it was an intentional, unintentional, fraudulent, willful, type of error. And I think with willful misclassification, they're not as strict, certainly enforced, and misclassification can certainly result in employer liability, such as full amount of income tax, both the employer and employee shares of FICA, and interest and penalties could be compounded daily, and all of the mentioned items here could equate to a pretty significant dollar amount. So super important to make sure that we are determining whether a worker is independent contractor or a wage earner, and we have the documentation and justification to prove that we proactively went through our due diligence to determine properly how this individual should be classified. When in doubt, to properly classify a worker, consult with an attorney, a certified public accountant, or an HR professional. After briefly examining, some of these consequences associated with misclassifying a worker, it's just important to remember that the hiring firm has the burden of proving the nature of the relationship. So, if an employee or a worker says that they want to just be paid at, 1099 to, not necessarily avoid taxes, but have the ability to pay their own taxes, at a time that's convenient for them, that's not a good reason to pay somebody as an independent contractor. Here's the form I was referring to, where an employer can get a definitive ruling as to how the IRS would view a newly hired worker and their status. Again, it's a very extensive and time-consuming process, but you can also find this on the IRS website. It's a few pages in length, and you can look at it, talk to an attorney or an accountant or some other enrolled agent to see if this is something that would be a good path to take in determining a newly hired worker for your organization. Some of the common mistakes here, employers, as I mentioned before, should not simply classify a worker as an independent contractor because they wanted to be one. They, sign a contract, does, assignments sporadically, commission only, or does an assignment, for more than one company. And these factors alone are not enough to categorize a worker as an independent contractor. It's the entire relationship, right, that has to be examined. Safe harbors, established as a defense for employers who misclassify a worker as an independent contractor. For example, an employer may have a defense if it had, some type of reasonable basis for not treating the worker as an employee. Although employers are strongly encouraged to consult with legal, this defense may apply if an employer reasonably relied on things like a recent court decision, a different IRS ruling that was published, or technical advice from IRS that was sent to the employer, or even perhaps a private ruling from the IRS indicating that that worker is not an employee. So, going back to the SS8 form, that would be, something considered of a, private letter authorization from the IRS. There's the relief provision. If you have a reasonable basis for not treating a worker as an employee, you may be, relieved to having to pay, employment taxes for that specific worker. And to get this relief, you must file all the required, federal forms and information on the basis of, your treatment with that worker. And so there may be some exceptions that apply, but again, a very extensive and time-consuming process. Excuse me. This program, the classification settlement, this may be the business may be assessed less taxes than it otherwise would, given certain conditions and if they're met. And it's only available for worker classification issues and taxpayers who timely file their returns. And again, you can find more information about this on the IRS website. So going back to, to proactive, so you wanted to, voluntarily, reach out to see if your workers need to be reclassified, whether it's some or all of, workers from non-employees or independent contractors to employees for, employment tax purposes. And, this particular program can offer partial relief from any past federal employment tax obligations for misclassified workers to eligible employers when they agree to, treat those workers as employees moving forward. Eligibility, big one here is, they really have had to have timely filed all the necessary forms, not be in an active audit. Interested employers can, apply for the program using Form 8952. Again, all this information here can be found on the IRS website. one thing that I, do have to note here is that as of publication, only the IRS is offering this federal tax relief. And it's unclear, by state if they would honor the federal. The DOL had something called PAID, which stood for the Payroll Audit Independent Determination that came out in 2018. But just as of last month, the 29th of January, effectively immediately that program is discontinued. And that was very similar, but under the DOL, not the IRS, providing employers the ability to proactively go through a self-audit to see how their employees, workers, independent contractors are classified without being subject to any penalties and fines. So I think we use the word important several dozen times because it is, it's important for businesses to understand that, employee versus independent contractor distinction is super important to their business, the individuals that they have working for them, as well as the government. And, an improper worker classification by IRS standards is certainly a costly one. And it's different for, every business that goes through that type of audit. And, even your well-intentioned mistakes can result in harsh penalties. So what I say a million times a week when, speaking with business owners is that you just, how do you know what you don't know? You possibly can't know every single employment law and the nuances that, come along with it. But as an employer, it is a responsibility. So lots of resources, SCORE, Paychecks, IRS website. My contact information is on this last page here. If anybody wants to write it down, I'm happy to speak offline. And I'm very happy and grateful for the opportunity to work with SCORE and get this content out to the business community. And I guess we'll open it up for questions, Claire.
Great, thank you so much. That was really, it's so informative, overwhelming and informative. So right. a few questions we have. One of them is, does paying a monthly fixed stipend wind up categorizing a staffer as an employee?
Monthly stipend, that's pretty vague. So there's a lot more detail that we would need, right, in terms of the relationship and what's the stipend for.
Okay. So Mark, you posed that question. If you want to clarify a little bit further in the Q&A, or you can reach out to Joanne directly to ask that question. Then we had, what's a question which is, what is the best non-IRS resource for guidance? Would it be a labor attorney or another professional resource?
So if we're asking for a non-IRS resource because we want to do our due diligence without bringing it to the IRS's attention, I'll say that I'm sure SCORE has a lot of resources on their site. Paychecks has a lot of sources. The IRS website does have the 20-factor test, which, although it's an IRS resource, the 20-factor test isn't something that you have to submit to the IRS, right? You can view it and make that determination on your own, as well as seek guidance from an attorney or your accountant, tax preparer, enrolled agent, things of that nature. Those types of individuals would be a good resource.
There isn't really like a one-stop shop, is there? It's sort of, you kind of have to go to a number of different places and make your determination, I guess. Does that sound right? Sort of do your research through as many avenues as you can.
Yeah, it's always good to reach out to the experts, right? In certain scenarios, I can change a light bulb, but if I have to do electrical work in my house, I'm going to call an electrician, right?
Right.
So if you're a business owner in, a certain trade, a certain service, you're probably very, very good at it. But if you have to, and you're not in the business of, developing a website, you would want to, reach out to, a web developer. So I think the same is true when we're looking at how are we paying our employees and what structure is best. Because there's the Department of Taxation and then there's the Department of Labor, and there is a lot of overlap, but then there are some areas where something only pertains to the Department of Taxation and not the DOL and vice versa. So, one-stop shop, you can certainly find a lot of information on the Paychex website. But otherwise, yes, you'd have to go to IRS and DOL and try to get all the information to make the determination on your own if you wanted to really take a deep dive.
Okay. And then
what about a crash course?
What about how can one determine what the lost Social Security contribution amount would be for a previously misclassified employee?
I'm sorry, can you repeat that?
How can you determine what the lost Social Security contribution amount would have been for a previously misclassified employee?
So if you're trying to calculate what maybe back wages and taxes and penalties and interest would be, I don't particularly know of a way to go about that other than probably raising a red flag and calling the proper agency to determine that.
Okay. So besides someone filing for unemployment, what would trigger an outside review for the status of a relationship?
So aside from an unemployment insurance claim, it could be, an IRS tax audit. That happened with a recycling company about a couple of years ago. One of the individuals that they paid as a 1099, personally, that individual was audited by the IRS. And so just another example, they went down the list of who were they receiving payment from and then audited those other individuals and businesses as well. And sometimes it's just random. It's a lottery that you don't want to hit. It's just a random audit. Mm-hmm.
Back to the software, so the stipend, the monthly stipend, it's software development work that's at a fixed monthly cost. The person decides their number of hours, the time when they work, and the deliverable priorities are negotiated.
So it seems like the monthly stipend is wages for that work. And so again, looking at the entire relationship, it doesn't have to be all, it has to actually be reasonable. So, not to be vague or try to avoid that question, but would definitely need to have a more in-depth conversation about that.
Okay. As Mark just said, the person who posed the question, it's complicated. Okay, and then another question is, if a company contracts with a staffing agency to provide part-time workers, is the company always in compliance on the issue of misallocation? Are there any issues? I think that goes into the whole shared employee world, which is different to independent contractors. Is that right?
Yeah, so if I understand the question correctly, if they're leveraging a staffing company for part-time workers,
that's correct. Yeah.
Are they? So if they're hiring a staffing company for part-time workers, typically they're paying the staffing company, and the staffing company is then paying those individuals, and technically those individuals are employees of the staffing company. From an IRS standpoint. So as long as the staffing company is paying them correctly, I believe, and they have a contract with the staffing company, if the staffing company is paying them incorrectly, I think that most likely would fall, but again, probably would need some more data to make an educated, intelligent decision on that. But it seems like it would fall in the hiring as the staffing company.
And then another question is, if you're an independent contractor, can you also be a part-time employee from the same company, or you can't also be a part-time employee from the same company? Is that correct?
I wouldn't say that you can't, but it sounds like there's a high probability that something's misclassified there. Either they should be 100% of the time an independent contractor or 100% of the time a wage earner. I would want to know why are they receiving two different methods of payment.
Yeah. And that is it for the questions. I'll just mention to everybody who's on the webinar, if you have any questions, feel free to put them in. Otherwise, we'll start to think about wrapping up and closing. So maybe I'll just sort of start my closing spiel whilst and see if any other questions come through. But so Joanne, thank you so much. It's really valuable information. And I think it's one of those sticky things about running a business that nobody really wants to think about, because it's not the fun stuff and it's not the stuff that makes you money, but it's so, so important from the back end of running a business to make sure that you're set up correctly and that you don't have something that can come back and bite you in the future. So really appreciate your presentation. To those of you who joined us, thank you so much for joining us. We are doing bi-weekly webinars at the moment. We are trying to do bi-weekly webinars, and we have webinars scheduled through to June now, every other week. So please check out our website at monmouth.score.org and have a look at the webinars we have coming up. Share them with your friends, share them with your colleagues, any other business owners that you know, because as you can tell from today's presentation, we have some really good, valuable things that help small businesses. SCORE is a nonprofit entity funded by the SBA, but run strictly with volunteers. We're all volunteers here, helping small businesses. It's something that we like to do. So if you are looking for a mentor, we have a whole host of mentors on our website as well. Please go ahead and look for a mentor, put in a request, and someone will get back to you. If we don't have a mentor that you feel that you may gel with, put in a request anyway, because we can try and match you to the right people to help you. That's about all I have to talk about with SCORE. Just this webinar will be on our YouTube page. It's on our Facebook Live right now, and you can rewatch it there. And couple other questions that came up. So for salons, and I'm assuming that would mean like spa salons, hair salons, beauty salons, can staff be paid as an independent contractor?
Can who be paid as an independent contractor?
No.
Excuse me. Staff. If this, again, going back to the relationship, it really depends on what kind of work they're doing, when they're doing it. Can they market, these services, to the public? Discharge, termination, is that something that the salon, the spa has control over? There's a lot there. And I'll be happy to send this to you, this presentation as a PDF, Claire, if you want to share it with the participants. So
great.
Yeah. And again, if anyone wants to talk, offline, it's not black and white, as we as we covered, like very high level today. It's not black and white, and it would really depend on the type of work.
Okay, great. Again, Joanne, thank you so much to all the participants. We will get you a copy of the presentation out. And again, as I said, you can see it on a YouTube channel and on Facebook.
Right.
If anybody has any questions, you can feel free to reach out to Joanne or reach out to a SCORE mentor. Joanne and Paychex partner with us at SCORE, so we have a great relationship, and anything we can do to help you, we would love to be involved. And that is it, everybody. Thank you so much. Hope you guys in New Jersey stay warm, and we'll speak soon. Thank you.